So the third element of a productive and lawful meeting is to obey open meeting and public records laws. Title 16, Section 554, school boards are public bodies subject to Vermont's open meeting law, which I'm bringing up on the screen now. This means that all school board meetings, including meetings of committees and subcommittees, must be open to the public. The public must be given notice and a reasonable opportunity to be heard at these meetings. And the amount and type of notice depends on the type of meeting held. So whether it's a regular meeting, a special meeting, or an emergency meeting, the requirements are different in statute, and those are all outlined in a nice handy chart on page 76 of the Essentials Guide. Just a few words about public records laws. Any person can copy or inspect any public record of a public agency, and that a public record is any written or recorded information regardless of physical form or characteristics which is produced or acquired in the course of public agency business. I was just at a training with the National School Boards Association, and a bunch of attorneys were talking about school board members whose text messages were requested under a public records request. So board members were texting each other during a board meeting, and those texts became public records. So anything produced in the course of public agency business could be subject to a public records request. So we advise board members to have separate school district email addresses in order to keep district business communication separate. And really the ground rule is not to put anything in writing that you would not want to see on the front page of the newspaper. Speaking of which, I don't know, some of you may be familiar with the situation in St. Albans this year, where a student working on a school-sponsored work site with his class got permission from his teacher to go home, get his gun in order to shoot a deer that was in the field they were working in.
Seemed like a good idea.
It's perfectly reasonable. He just lived around the corner. But the episode resulted in the suspension of the teacher and the student, and ultimately,
the death of the deer.
Yeah, the death of the deer. Oh, yeah, first and foremost, the death of the deer. But and ultimately, a reprimand from the Vermont Secretary of State to the school board. In a response to an inquiry from the Free Press, Secretary Condos criticized the school board for failing to give a true indication of what had happened at a board meeting in their minutes, which are a matter of public record, as you know, and for improperly wording a motion to enter executive session to discuss the teacher discipline. So the question of whether and how to enter executive session comes up a lot for school board members. A motion to enter executive session must fall within one of 9 statutory exemptions. And so in the next few slides, I've prepared a series of scenarios for you to consider. And this is where we're going to use the hand-raising function. I'm going to rely on Steve and Harry to help with this. But when you read the scenario, I want you to raise your hand if you think the board can enter executive session to discuss the topic. And if they can, I want you to just, this is an exercise for yourself, think about what the wording for the motion to enter the session should be. So let's start with the first scenario. Can a board go into executive session to meet as a board with the staff of the VSBA to conduct a board self-evaluation? How many of you think that's an appropriate, put your hand up on the computer if you think that's a permissible? What?
Is that everybody, or is there some other page?
Okay, we have a few hands.
Let's see, 1, 2, 3, 4, 5, 6.
Six hands.
7. Oh, wait, one's down, one's up, one's down. 1, 2, 3, 4. Oh, well, now we're down to, we were as high as 8, now we're at 6.
Okay, so
7.
So the answer is no. Board self-evaluation does not fit into one of the 9 statutory exemptions. So boards really do have to engage in evaluation and planning in a public setting, even if it might cause discomfort or embarrassment, which is sometimes surprising to people. Okay.
keeping in mind that this is a board self-evaluation. You're not evaluating an employee. You're evaluating
yourself.
How you function as a board.
Right. Okay. Next scenario. Raise your hand if you think the board can go into closed session to meet with the superintendent to discuss a leave of absence. Good. Lots of hands. Great. So, yep, lots of hands, and the answer is yes. This would fall under the employment of an employee exemption. And I'm just going to give you my take on a good way to word the motion to enter that particular session. I make a motion to enter executive session for the purpose of discussing an employee's leave of absence request. Okay? So the next situation, can the board go into executive session to discuss highly toxic drinking water in the schools as a result of a public health test? What do you think? No one.
No.
Raise your hand if you think you can go into executive session to discuss these results. Interesting. Not a one. And you all are correct. So the test here was conducted by a public agency. The results are a matter of public record, and quite frankly, you think people really need to know about this particular problem.
But I think it is helpful though just to think about the change in our public mores, because I have no question that not too long ago there may have been a lot of people who would have said we don't want to create undue alarm, yeah. Until we have more information or whatever.
Okay, great. So the next scenario is, can the board go into executive session to discuss a letter from their attorney giving their opinion about the viability of a lawsuit? Looks like we have a strong majority of you think that this is appropriate, and it is under the civil action exemption. If a board is considering whether to bring a lawsuit against a party for breach of contract, they have the ability to consult with their attorney in a closed session, because to do otherwise will compromise their position in the case, may compromise their position. However, I do want to note that this does fall within the category of exemptions that requires a board to find that premature public knowledge would disadvantage the board. So it's not enough to simply say, we're communicating with our attorney, we're going into executive session. You really need to find that premature public knowledge would disadvantage the board. So the appropriate wording for the motion in this case would be move to enter executive session for the purpose of discussing a contract with the bus company, since doing so in public session would clearly place the district at a substantial disadvantage. All right, so the last scenario. Can you go into executive session to sign a contract with the school's new principal? The identity of the principal would be announced at a staff meeting later in the day. Raise your hand if you think this is an appropriate reason to go into executive session.
All right, we're at 1, 2, 3, 4, 5, 6, 7, 8. This is one of the more divided. Well, let's see, 5, 9. We're at 9. 9.
Okay, so about a third of you. Actually, in this case, even though it involves a contract, entering executive session would not be appropriate, because it doesn't place either party at a substantial disadvantage, which is another area where that consideration needs to be brought into consideration. Since the announcement will be made later in the day, and since the scenario is not describing the negotiation of terms of a contract or a collective bargaining agreement, it's really ratifying a contract. So executive session would be proper when the board is negotiating the terms of the contract, but once those terms have been established, the board really has to ratify that contract in public session.
There are a number of legal questions here, and I don't know if it's should we take a couple of these before you go into the next round?
We can, although I reserve the right to answer them over email at a later date.
Yeah. Here's an interesting one, and I think I have a clue on the question, but I think it's one that we should be able to answer easily for everybody. A board can do a board retreat that does not have to be open to the public or keep minutes. And then he said, you don't have to answer this tonight. I don't want to throw you off. But I guess the question is, I am assuming when the board meets, even for a retreat, it's technically a public meeting. Most people don't have any interest in attending such retreats, but I'm assuming that technically when a majority of the board meets.
Anytime you're discussing the business of the public body, unless it falls into one of the 9 statutory exemptions, it is a public meeting.
Okay. And there was one other I was going to
Okay, so I'm going to just speed through these executive session requirements since we've, most of you seem to have a pretty good handle on it. But just to note that the board first must meet in public session and then vote to close the meeting, and by a motion that indicates the nature of the business. So there's some level of specificity that needs to be included in that motion. A lot of boards make a motion to enter to discuss personnel matters or contract issues. And the Secretary of State and his letter to the St. Albans Board and in presentations it's doing across the state is really saying that's not sufficient. It really needs to be a little bit more specific in order to give the public an idea of the nature of the business that was discussed. It also keeps the board honest about what it's discussing while in executive session, because you're only supposed to be discussing the subject matter that was identified in the motion. And personnel matters is a very broad topic that could really allow you to get into a whole lot of stuff you shouldn't be talking about. Again, the permissible reasons for entering executive session are listed in Title I, Section 313. Boards can invite their attorney, administrative staff, and persons who are subjects of the discussion or whose information is needed into the executive session. That is not required. It's a board's discretion to invite outsiders into their private closed meeting. And no decision may be made in executive session. Ultimate action has to be taken by a motion and vote in open session. And again, that motion needs to give an indication of the decision or the vote that's being made.